Welcome everyone to ABLA's latest in its series of viral webinars. My name is Julian Arndt. I'm a director at ABLA, and I'm very, very lucky to have with me Alana Rafter, one of our senior associates, joining me today to talk about bullying, harassment and discrimination. Now, Alana, people is why I got into this game. I like people. I like what they do. I like analysing what they do. This is a topic, and this is a series of offences and prohibitions in an area of law which just keeps on giving, if you like people. It's great to have you with us. You are an expert in some of these areas of law, and it's going to be great to talk about them today.
Yes, very excited to be talking about my favourite topic of psychosocial hazards in the safety world, which very much overlaps here because bullying, harassment, discrimination are, of course, very common psychosocial hazards because they can arise in almost every workplace that involves your favourite people, and they can potentially create psychological harm. So it's very important businesses, employees know how to manage these hazards and risks.
Yeah, we won't bury the lead there because psychosocial hazard is a topic, is a buzzword. Everyone wants to know about it. This is a topic which has a huge response in terms of questions. We've received plenty of questions in preparation for this webinar. I'm sure we'll have some takers on the iPad or the tablet here to ask some questions during the presentation, and we'll get to them at the end. As we said we're going to be talking about bullying, harassment, discrimination. We're also, because at ABLA, experts make things simple, we're going to be trying to talk about what you can actually do to meet your obligations in this area, to, I guess, react when things go wrong. And we'll finish off with how we can help and also answer some questions as they come through and as we get to them. So, starting with bullying. Now, anyone who's been to high school knows what bullying is, but in the context of work, it has a very specific definition, doesn't it, Alana?
Yes, and on the slide there, we can see it in a pictograph image form, which is very helpful. We're setting out the Fair Work Act definition, and there you'll see these are the features you need to meet the definition of bullying. So we start off with we need an individual or a group of individuals. The next element, that repeatedly behave unreasonably towards a worker or a group of workers. And then the clincher of all of that is that it creates a risk to health and safety. So we need those 4 features, if I can say, for it to constitute bullying.
The hallmarks of bullying is, 1, is it actually creating a risk to health and safety? Superficial kind of nonsense, nothing stuff. It's not going to be bullying because there's no risk to health and safety. But I think the touchstone of bullying is it repeated? Now, a one-off incident, a one-off bad joke, a one-off piece of criticism, a one-off, a one-off anything, by definition can't be bullying. It can be other things though. And this is a topic that we'll return to probably a number of times during today's presentation. Bullying, harassment, discrimination are all overlapping concepts. Often if you are bullying someone, you're probably discriminating against someone. Often if you're discriminating against someone, you might be bullying them. And all of those things can constitute harassment. So merely because it's a single incident and doesn't satisfy the bullying definition doesn't mean that you're, free and home.
And I guess another point to just address at this point as well is that we've said worker there. So it's not just limited to an employee, this definition. It can apply to other people, such as your contractors, apprentices, and much broader definition than just employee.
Well put. So I think we've covered this slide broadly. A particular type of behaviour doesn't need to be repeated. So it's not the same thing again and again and again. It can be a sort of a spectrum of the same type of vibe of behaviour.
Yeah, you wouldn't be finding yourself on a technicality because you bullied via email on one occasion and then it was via a comment the next. That wouldn't mean, it's different types of behaviour. Suddenly it's not bullying. No, it can be different types of conduct, and that's meeting that repetition that we need to see there.
Everyone knows this, in that this is how actually bullying occurs. There is a range, a trend of behaviour, putting someone under the microscope, putting someone on the outer, excluding someone, making critical comments about that person. All of these things are happening in unison to creating a risk to their health and safety, where they say, well, actually, this is not right. I don't feel good about this, and my health and safety is suffering as a result. Cue bullying claim. So, at work is an interesting one in the times in which we live. I think everyone watching this webinar will be across the fact that at work does not just mean the office. In fact, it's quite a controversial statement to say you have to work at the office to perform your work. Clearly, at work is broader than just simply the office or simply in the workspace. It gets difficult though, doesn't it, Alana, where we start to talk about social media, particularly in the context of bullying.
Yes, this is where we're really starting to look for that connection to the workplace, connection to the performance of work. This is where social media posts, for example, that's done after hours, if that can be accessed by a person during their work hours on their phone, on their lunch break, even during their shift, that comment, if it's an unreasonable comment of the bullying kind, can impact that person in the performance of that work. And that's where we're getting that connection to the work.
Yeah, I would say it's not that it can, it will impact that person in relation to the performance of their work. And I really see this as a tree falling in the woods type scenario. If someone at work finds out about particular unreasonable behaviour that's going on outside the workplace, maybe a critical social media post, maybe a critical WhatsApp sort of post where someone is criticising or let's use juvenile terms because some bullying behaviour is juvenile, teasing behaviour. If that's going on WhatsApp and the employee finds out about it, absolutely you're going to have a connection to work because it's going to impact the workplace. It's going to impact their psychosocial health. It's going to have an effect. So I think it's very, very rare that we can say in 2024, well, it's completely outside of work. It's got nothing to do with the workplace and therefore it's not bullying. Very, very rare. Sometimes there's some really messy personal situations, family disputes, relationship disputes, which the line is slightly more blurry. As ever, we lawyers like to say it depends. If you're trying to work out a very messy dispute, please give us a call because we do have some experience in this area. So, yes. Alana.
And there's the whole range of examples that we've been trying not to say, but there they all are. The practical jokes, intimidation, unreasonable criticism, all these different things. We can categorize that as psychological bullying because those are the types of things that risk someone's psychological health or psychosocial, etc. And then on the other side, a much shorter list is the physical.
The old school stuff, which hopefully is not part and relevant of 2024 workplaces. Alana and I, before going live, had some interesting discussion about initiation rights. I think it's probably very rare to have initiation rights in normal, typical workplaces in 2024. An interesting area of developing law is initiation rights in the sort of professional sport context. And as sport becomes more professionalized and it becomes, people start referring to it as a workplace, some of those initiation rights, way rookies are treated, punishments for failing to reach certain standards are being looked at and will be looked at by the courts. But I think for most people, if you have initiation rights in your workplace right now, I would be carefully thinking about taking some steps to minimise them because it's very, very possible that they might be a form of bullying. Upstream and downstream bullying, again, I think our very educated viewership will be across most of this. We hear a lot from managers, from workplace investigators, from HR professionals that I feel like I'm being bullied investigating someone who's made a claim that they're being bullied. Alana, can go both ways. Yeah,
that's essentially the key point. And it's in that second bullet point there as we can sometimes just get a bit too focused on bullying at one level and one level across a team or workers. But of course, managers, supervisors, people in leadership roles, they can, of course, be victims to bullying themselves. And you just need to be aware of that. Is that something you also need to respond to if and when it happens?
Yeah, the examples there are interesting. For example, female manager not respected in the workplace based on gender, payback for manager doing their job, taking disciplinary action. I've had some recent experience with some clients complaining about younger managers having the heat put on them by older employees that they're managing. and some of the disrespect that can be coming upstream. It is a difficult area to advise on because obviously the role of manager requires you to occasionally make some tough decisions, occasionally take some flack for making those tough decisions. Leadership can be difficult. So merely because it's uncomfortable for a manager does not necessarily mean that they're being bullied. But there is a line and there is a reasonable way that you treat anyone in your workplace. And as an employer, you have a responsibility to ensure that everyone's protected. It's usually not going to be enough to say, well, they're a manager, they should be able to cop it, because sometimes they can't.
I guess the next slide leads us to this question, well, what is bullying? What's not bullying? Yes. You're touching upon that a bit with the reasonable management of performance. That's where I think you were going there.
Brilliant. So what isn't bullying, Alan?
Well, we've got reasonable supervision. So, of course, managers can still do their job. So that's with that reasonable management of performance, reasonable supervision, counselling and discipline. These are decisions that managers will make in the course of their work, based on, informed, of course, by the circumstances. And this, of course, is not automatically bullying. Now, one caveat to that I would say is if you're entering into the territory of unreasonableness in your execution of any of those 3 dot points there is an argument that we're getting into the territory of bullying.
I'm interested by the 4th dot point. Poor management is not bullying. It certainly can be. Poor management certainly can be bullying in circumstances where it's unreasonable. Making bad decisions is not necessarily bullying. Making decisions that that people disagree with is not bullying. So if you have a manager and you make a decision and one of your subordinate employees doesn't like that decision, it's not bullying. It's just it's just managerial prerogative exercising a different decision. But yes, when it gets to unreasonable risks, you're looking at the potential of bullying. There's always a technicality on a slide like this, a single instance.
Need that repetition, as you said before.
And it's a point we're repeatedly making. So let's move on. Now, we didn't bury the lead. We talked about psychosocial hazards at the outset. It's all anyone seems to be asking about. It's everywhere. Alana, this is a particular interest of yours. What about psychosocial hazards in terms of bullying? And I might just even, pass the baton over here.
I'm on it.
While you riff on this subject.
Well, the key thing here to be aware of with bullying, harassment, and discrimination is each of these types of conduct can arise from the way workers interact, people interact with customers, clients, etc. And even, as we're saying, the way people interact with their team or supervisors. The way we design our work can create an environment that either encourages or discourages bullying, harassment, discrimination, etc. But all of these decisions we make, all of these interactions can create a risk to psychological health. It can create that harm that we have a duty to ensure is minimized and eliminated so far as reasonably practicable. So I'll put a slide out there to crystallize it a bit more. The key thing is that businesses cannot ignore hazards to psychological health. There was a time where physical hazards were the focus, and that's where businesses put a lot of their energies in.
Yeah, and I think and people's awareness, whether they be employees or unions or anyone, their awareness was mostly on those physical risks. Everything seems to have shifted in that there is a real awareness now that risk can be psychological and that employers have responsibilities to mitigate against harm in those areas as well.
And all businesses, employers have always had this duty to ensure the health and safety of their workers and others in the workplace. And that's always included psychological health. I should say that from the outset. But the reason it's getting more attention now is because we've got a whole range of regulations in multiple jurisdictions across Australia, specifically addressing psychosocial hazards. And we have codes of practice providing specific guidance on how to comply with that duty. And I might turn to the next slide as well here. So what this sets out is the traditional risk management process. So with all hazards, your physical hazards, this is the typical process everyone tuning in is probably familiar with. You identify the hazards, you assess the risks, control the risks, and review those control measures. for the majority of hazards, you apply the hierarchy of controls.
And I'm thinking, when I look at this, I'm thinking things I can trip over, things I can burn myself on, things that I can get my hand or leg stuck in, things I can slip on. Risk as have been traditionally understood in a work health and safety context. Obviously, there are different kinds of risks, Alana.
Yes. And now we're edging more towards these risks to psychological health, and we've got a new approach here. In most jurisdictions, we're now moving away from those hierarchy of controls. And what we need to do is be identifying as many control measures as possible. So we're not simply saying, can we just eliminate it? Can we put in an engineering control and is that call it a day?
Yep.
No, we're looking at multiple control measures in this space, and this next slide will crystallize it completely. So the new regulations in the psychosocial space really focus on a change to controlling those risks, minimizing them as much as possible. And this is the guidance that's provided. You have to consider all the relevant factors, and these factors are listed on the slide there. So we're no longer just going through the hierarchy of controls. We're looking at our risk assessment. How does it interact with other hazards? The design of the work, the physical workplace, information, training, instruction. And what these new factors are getting at is you need to do more than just put in a policy.
It's much more sophisticated, isn't it? And I'm sure in part the reason why it's much more sophisticated is because the risks are much more complicated. They're much more difficult to manage. And I think the key point is it's impossible to eliminate psychosocial risk.
Now, in the jurisdictions on the slide there that are purple with a little star next to them, the reason why they're highlighted as special is those jurisdictions have not completely done away with the hierarchy of controls. So they still say, essentially, start with the hierarchy of controls. But if you cannot eliminate the risk, that's where you've got to look at these new factors. And I think that's the point you really captured is with risk to psychological health, psychosocial hazards, you cannot eliminate these from the workplace. Your priority will be on minimization. And that's why you have to do more than one control measure to achieve that minimization in most cases.
So, taking it back to bullying as a subject, obviously you can have a policy prohibiting bullying. You can think deeply about how to not hire bullies or to deal with bullies as they arise in your workplace. But you can't stop managing people. You can't stop people interacting in your workplace. And therefore, it's very, very difficult to say with any certainty, well, we can eliminate the prospect that bullying will ever occur here. It's just too complex a behaviour. And it requires a sophisticated response where you actually think deeply about how people are interacting, how people are given work, how people receive work. And yeah, it's a challenge, absolutely. And it's an area of law which is developing, but it's one that I think people need to get on board.
And those were exactly the questions that you ask yourself when you're considering these factors. So what information can I provide to my workers to, one, communicate the expectation, and two, talk about so that they know what to do if they encounter this behaviour? Do I have a system in place for taking disclosures, reports of this behaviour, grievance procedure, for example? In fact, asking those questions, using them as prompts to see, can I do something in that space?
Absolutely. So I think we've broadly just covered most of those things in terms of you thinking about how to manage bullying in the workplace. There's an interesting thought bubble about the right to disconnect. Right to disconnect is an imminent part of modern awards, is a current part of the NES. It got a hell of a lot of media exposure when it first came out in the legislation, yet to be tested in terms of how it's actually going to play out. In the context of bullying, I would suggest to the viewers that if someone is exercising their right to disconnect as a response to what they call bullying behaviour, you do have a problem. Hopefully you can create a system where people do not completely what would you call it? You call that disengagement. Say, I can no longer respond to this manager because they are hounding me outside of hours, or I can't actually deal with this anymore. The right to disconnect hopefully will only apply in much lower stakes scenario than bullying. But to be honest, it might help. It might help remind some managers who are perhaps slightly more ambitious about when they contact their employees, maybe to back off slightly. And who knows, maybe that might sort out some bullying claims. I'm not sure.
And an additional point on this design of work I just want to comment on is something that was on the other slide with this interaction of these hazards, how that can increase risk. Now, with the design of work, and a good practical example of this, if you're not putting on enough staff on a shift, or if you're overloading the roster, for example, this can impact the working environment. It can intensify the stress potentially of a shift, or have people with nothing to do on the shift. And this can create an environment that might increase the risk of bullying behaviours. So that's what we mean by that interaction.
Yeah, well, your comment about some people having too much work and other people having not enough work is a very, very relevant comment in the bullying context, because particularly in some corporate environments, both of those situations are very bad and can very readily be made into a bullying complaint. I'm being frozen out. I'm not being given any work, or I'm being overloaded with work to try and force me to quit. You see those scenarios happening a lot. That's about the design of work. It might not be intentional. It probably isn't. But it may be the design of work, how you're allocating work is not fit for purpose and it's creating risk. A couple of questions that came in from viewers prior to the webinar going live. Alain, how far does a business need to go to identify potential risks for psychosocial hazards in the workplace and protect themselves as an employer and their staff? Rafty, you've probably covered a fair bit of that in the last sort of 5 to 10 minutes. Is there something else that you would add for Alain?
The only thing I would add here is it's really focusing on that first part of identification. How do I know when I've identified enough? And the advice I always give businesses is to start with the common psychosocial hazards. These are listed in all of the codes of practices for managing psychosocial hazards. And the reason I say start with this list, which does include bullying, harassment, low job control, job demands, etc., is because they're common for a reason. They're reasonably foreseeable in the majority of businesses. So starting there will prompt you to consider them.
Yep.
Next, I would say make some observations of your own workplace. You're the most informed person about your business, so just looking around. Identify any vulnerable workers, and that vulnerability can be the young and the invincible. If there's anyone with cognitive...
Invisible?
Invincible. Young and invincible. Cognitive difficulties, language barriers, or they've been exposed to traumatic exposures. And I guess the last thing would be also look at your data. And this is all things that will help you potentially identify hazards you might not have considered. Now, if you've done all that, the key thing that will save you then is you'll set a deadline, you'll set a time to review all this. And that's where you might look at factors such as residual risk, or if your control measures are actually doing what they need to do. So it is an ongoing process that you'll always return to. That's my tip for identification. Go through those 4 categories.
Question from Yvette. This is an interesting one. When Gen Ys complain about Gen Xers and Boomers, is that bullying? For exam... being pulled up for using a ... or a thumbs up. Gen X does not find this insulting, but Gen Y does. Now, with absolute respect to this question, I don't have anything to say. I don't even know. I don't know whether people have been laughing at me for using ... or thumbs up, whether they've been angry. What do you say to this, Alana?
We've been very angry at you, children. Yeah. With questions like this, I always I'm resisting the urge to say it depends, but I always go back to those elements we started with, and that's how I test whether or not something is meeting a particular unlawful conduct. So I'd start off with, okay, well, we're dealing with a worker that's engaging in this conduct, so we're crossing off the first thing.
Yep.
The factor that causes me a bit of pause is whether we're entering the territory of repetitive and unreasonable conduct. This is where I really think we'll need more factors and circumstances to assess whether or not we're hitting that unreasonableness. Let's just assume this is happening all the time.
Yeah, and let's say that the Gen Y person who apparently finds this insulting has said, please stop doing that, or made some comment which indicates their difficulty with the practice. That sounds like more repeated behaviour. It then gets to creating a risk to health and safety. Now, This is context dependent, right? Absent anything else, I wouldn't have thought that the use of thumbs up or ... is going to result in a bullying claim or a successful bullying application. But in some other contexts, where the stakes might be slightly higher, where there is a pattern of exclusion, where there's a pattern of certain groups in the workplace ganging up on another person, who knows? This could fall part of some form of bullying conduct.
Yes, of course, especially if it's in a meeting. I always need that context to picture. It's in a meeting and they're not just pulling them up, but then gesturing to other people in the group, adding to that undermining of, say, if it was a manager or even if it was just another team member. And all these factors is what a court or a tribunal would look at to see, is it getting to that unreasonable?
This is, it's a classic topic where some people bristle at the prospect that something as minor as what someone puts in a text message could amount to bullying. I can hear people saying, well, this is PC gone mad. What's the world coming to? All of those things. And I appreciate that viewpoint. The reality is that no court or tribunal is making a finding of bullying that what goes in a single text message is going to be bullying. All of these things happen in a context. And we also need to be aware of the fact that, yes, some claims of bullying are not grounded in reality. Some of them are opportunistic. Some of them are in response to performance management, where people say, well, I'm going to make a claim of bullying to try and get out of losing my employment. But some claims of bullying are really absolute reality. Some claims of some types of behaviour create real serious risks to people's health and safety, their enjoyment of work, and so forth. So little things can add up, and it's an interesting question. It all depends on the circumstances. And look, if you have a situation like that, very, very happy to discuss it with you, because this is why we like this area, because it has interesting little human interactions in it. Harassment. So we're leaving bullying, but clearly, as we've said before, there is some overlap between harassment and bullying. Harassment's unwanted behaviour. It offends, humiliates, or intimidates. It can create a hostile environment. I guess the interesting part, or a topical part, or something to comment is that, Alana, there's a range of different pieces of legislation that specifically prohibit harassment. We've got some on the board.
Yeah, so there's some of the more grounds that typically cut across most of the state and federal legislation. So this is an area where you always need to, if you're getting into the territory of wondering if it's specifically unlawful, you might need to check your state legislation.
Absolutely, they're all different, right? And some of them are much more complicated and much more detailed than other states. Our viewers in Victoria should be aware that their jurisdiction in this area, discrimination generally, is much more detailed than in other states. But the thing with harassment is you don't need a specific piece of legislation saying something is unlawful for it to be harassment, do you?
No. And this is something that most of our listeners, I'm sure, have already grappled with in a policy, a harassment and discrimination policy that sets out that this is unacceptable behaviour.
Yeah, look, and the other thing is people have, as you say, people have a policy, and what your policy says is harassment will be the standard that you're held to and that your employees will be held to. So harassment can be many things. There's not necessarily specific law that you point to. The reason it's so different from bullying is that a one-off incident can constitute harassment. That means if there's an incident, a bad incident, absolutely it can warrant the most serious of sanctions, notwithstanding that there is no repetition, notwithstanding that there might be an apology, notwithstanding that it was a one-off mistake. It can certainly be harassment, and that can be actionable in some form of disciplinary procedure. The second box is good advice. Quick response to harassment and appropriate response to harassment is something, you can take that as read. Alana, where do you see the problems for managers or employers in responding quickly and appropriately?
The key problem that arises in this space is when you ignore knowledge that arrives at your doorstep in this space. Whether it be a manager or a supervisor sees an incident happen or is informed about an incident and they go, oh, that's a very difficult thing to hear, or maybe it's not quite a problem just yet. I'll park that. I'll just leave that for now. And then that's where it ends. Doesn't go any further.
Tomorrow's problem.
Yeah. And that really will become tomorrow's problem if that's the approach that's there. So it's really important that there's a system in place that managers, supervisors, etc. know what they need to do if they find out about this information, if they find out there is either they see a harassment happening or they receive a disclosure complaint, and they need to know the steps they need to take. Do they need to escalate it up? Is there a procedure that's already exists that they can follow? One, does a procedure exist full stop?
Have a process. We're going to keep coming back to that point, because if you know the first step, it doesn't become tomorrow's problem. It allows you to respond quickly because you at least know the full step. And the best thing about that advice is that it helps everyone. It doesn't just help people who are at risk of being harassed. It doesn't just help the employer in managing their risk, but it actually helps the harasser, in that someone who does the wrong thing, someone who oversteps the line, perhaps in a very minor way, is informed, is told, is managed, is that the issue stops at that first little incident, the first little slight problem, as opposed to, well, everyone puts their head in the sand, no one does anything about it, and then you've got either a full-scale bullying claim because the behaviour has been repeated, or you have some kind of workers' compensation claim, or you have a situation which you can't come back from, rather. It's beneficial for everyone if we deal with things quickly and if we have a process to do so.
And that education piece that you touched upon, that in harassment, particularly some of the newer types, if I can say that, like sex-based harassment, there can be a bit of a learning curve for workers, not necessarily understanding that a particular sexist joke is actually a form of harassment, that they cannot engage in that that's not acceptable behaviour in the workplace. And so there might be, the manager or supervisor might be the person that needs to actually educate people when you say it's important to think of the harasser in this context.
Yes, it's an outstanding point, and it's almost precisely the type of scenario that I'm talking about. Some people do not know that they're behaving inappropriately. Some people do not know that people are being offended by what they say or do. It's better for them if they are caught at that point, not so that we can dismiss them and publicly shame them, and not for that reason.
And it's also not a defence to the conduct.
Correct. Either. It isn't. But the point is, if you deal with small problems quickly, you're just much less likely to have big problems. And we will get to the positive duty shortly. You queued me up. That's excellent. Excellent. So is sexual harassment just simply another form of harassment? Is just sexual harassment another form of harassment that's on a long list along with everything else?
Part of me just wants to say yes to be difficult, but no, of course.
It's not, is it?
It's not.
It's not, because the Parliament, in its wisdom, has made a decision to create a whole structure around how to deal with sexual harassment, sex-based discrimination, hostile work environments. And it has, the key in all of this, the creation of the positive duty to prevent those things, means it is a different form. It is different grading in terms of what you need to do as an employer to comply with the law. If you treat sexual harassment and the various types of behaviour that are covered by the positive duty in the same way that you treat everything else, you're going to probably fall short. And this is probably, if you've heard me speak at all in the last 2 years, you would know, because I seem to speak about this a lot. For anyone who hasn't been able to plug into positive duty, it's a duty which requires employers to take reasonable and proportionate measures to eliminate sexual harassment, sex-based harassment conduct that creates a hostile work environment, and victimisation as far as possible. Obviously, what is actually required will depend on the type of business, the size, the scale, the characteristics of the business. But it has been our strong advice, and a lot of employers and a lot of our clients have been on the journey, that the positive duty requires you to have standalone instruments. So standalone policies dealing with the positive duty, not just tucked away in the general harassment discrimination policy, but also, to your point earlier, Alana, often different grievance procedures. So if the positive duty is new, please get in touch. please get in touch, because it does require something more than just simply run-of-the-mill discrimination protections, harassment protections rather. Hostile workplace environments, it's a new offence under the Sex Discrimination Act, and it falls within this category. And I just want to quickly take us through hostile workplace environment, because it's interesting in the context of harassment, because a lot of people think harassment is, well, behaviour directed at a particular person. Hostile work environment isn't necessarily that.
It's always a mouthful to describe the definitions of this one, where it's an unlawful to engage in behaviour which would subject another person in the workplace to a hostile workplace environment on the grounds of sex. And then we have what a hostile workplace environment is there set out there. But the key way I like to contextualise this and get people to understand this offence is to those examples at the bottom of the slide there. This conduct is not limited to a particular type of conduct, it's ranges. So it includes examples such as displaying obscene or pornographic materials in the workplace, general sexual banter, so this could be people actually engaging in sex-based harassment over here, and offensive jokes as well. All of these different types of conduct that may not necessarily be directed at any one person. This can all be found to be conduct that contributes to a hostile workplace environment, and this is conduct that all employees now have a positive duty to eliminate from the workplace.
Yeah, so and that's the key point, Alana. It's not just that, well, if this is happening in your workplace, you've got a problem that you need to fix. You actually need to proactively get ahead of this and take steps to prevent this from happening. And we're talking risk assessments, we're talking standalone policies, we're talking training for employees, managers, board level. Like these are steps which are required by the law. They're not necessarily nice to haves. I mean, in my view, they have to haves, particularly depending on types of, organisations, institutions in certain industries.
Now, there's an argument that you might already be doing great stuff in this space because you're complying with your safety obligations. When we hear proactive, we all automatically think of, oh, that's my duty under the Safety Act. But just note there's now a potential for contraventions in both spaces there. So that's why we still separate the two out, so you're aware there is a different offence under safety and in the Sex Discrimination Act space.
Absolutely. So we have definitely covered this slide. That's good. Helen loves this slide. It's
screenshot this slide.
It's super simple. Obviously, we're going to spend the next 4 hours explaining it. No, what I need to say about this slide is, yes, people are responsible for their actions, and someone who is behaving inappropriately in the workplace can be held responsible for their actions. But managers who are involved in someone behaving in an inappropriate way can certainly face liability. Typically, what we see is employers being sued, which is vicarious liability for the conduct of their employees or their managers. And lastly, the positive duty, which kind of hovers over everything. That's not, again, the positive duty is not if something bad happens. It's independent, whether you have a problem, whether you have an issue, whether you have a complaint. You need to comply with the positive duty ahead of the problem. And if any of this is scary, or if anything is interesting to you, if there is something that's keeping you awake at night, or if you've made any problems tomorrow's problem, please give us a call, because there are steps that you can take to fix these things to mitigate the risk going forward. Question time. Do you want to read that out, Alana?
Let's see from Helen. Where do you find that employers are commonly falling down in their responsibilities in relation to the legal obligations around harassment?
I will have a go first, because I'll keep banging the drum about this. I think if you are not treating sexual harassment as a special, important, distinct form of harassment from a legal perspective, I think you're probably ignoring the change of law that's occurred there. You haven't engaged proactively with positive duty. If you haven't thought about whether you need a standalone policy, and many people haven't, I think that's somewhere where I see employers falling down. Anything else on this point from you?
An area I see people falling down on, and I touched upon it before, is not giving enough support to managers so they know and are confident on how to respond to complaints and disclosures that come across their way.
Yes.
Because some harassment complaints or disclosures can be quite sensitive, or they might be confronting, and they can just be difficult for anyone to deal with. So it's no criticism of anyone that feels a bit uncertain in this space, but this really is an area where employers can provide additional support, whether it be training, reviewing the procedures that are in place, or ensuring that all managers and leaders know what procedures we follow when this happened. How do you document informal versus formal complaints or disclosures? We really need systems in place here, because that's one that will demonstrate that you're proactively managing your duties in this space, that you're taking those positive steps for prevention. And also, when we then hit the territory where remedial action's needed, where we need to respond, we have a process.
It's great. It's a great insight, because some of these problems, some of these allegations, some of the accusations, some of the personal scenarios that are created by this area of law are very awkward, very sensitive, very highly charged. No one has the answer from the outset. That's why workplace investigators exist. That's why people ask for legal advice. It's not about knowing the answer as soon as the complaint comes in. It's about knowing the first step to take. The only way you can do that if you have a process or some kind of procedure. And I would invite anyone who's watching us give this webinar, I'd invite you to ask yourself the question, if I got a discrimination, harassment, a bullying complaint, what would be the first step that I would take? And if you don't have an answer to that, I would very much, I'd love a call, and so would Alana. Discrimination. So I think I mentioned discrimination 3 or 4 times, and it demonstrates the overlapping nature of all of this. The dictionary definition is involved there. Under discrimination law, it's unlawful to treat a person less favourably on the basis of a particular protected attributes. Obviously, those protected attributes aren't infinite. It will depend on the state. There's some examples there. It's very interesting reading about the differences in the state's protections of various protected attributes. And as I say, the Victorian listeners will know that your state is very progressive and has a long list of protected attributes, which are interesting and something that other states don't necessarily need to worry about as much. But discrimination per se isn't unlawful. Obviously, people need to make decisions between things at all times. The question is, well, why are you making the decision?
And that's why we have those particular protected attributes. And more.
Yes, and this is a very incomplete list, and the interesting one, I guess. Looking at that, Alana, does any pop out as something that you see on the regular or in sort of?
Not in my workplace.
No. Well, I wouldn't have thought so. I mean, it's interesting. Criminal record is interesting in some contexts where people have their previous criminal record or spent convictions held against them in the hiring process.
Yes, the ones that are popular I see amongst clients asking questions will be disability.
Yep.
And disability in particular, because we have the lovely federal act that regulates disability discrimination in that sense. And then we have state acts, and there's differences between both schemes.
Yes. It just is beyond the realms of the scope of this webinar to go into each particular area, and all of them are very interesting. But we will move on. Direct discrimination is the first type of discrimination. It's less favourable treatment based on the grounds of discrimination. And the example I always use, and everyone's probably really bored about this, is let's say you had a police force and you say we're only going to hire men. That would be direct discrimination on the basis that you weren't hiring someone directly because of their gender. Indirect discrimination is different. It's a requirement to comply with a particular policy or rule that doesn't seem like on its face is discriminatory, but will because a particular attribute kind of affect different groups.
I'll give you my favourite example for indirect discrimination. We'll stick with the police force, as I like that. We're going to institute a new rule that we're only going to hire people that are 6 foot and taller. We think that will make a fantastic force.
That doesn't sound discriminatory.
And you know what? There'll be women and men that both are less than 6 foot, and we're going to discriminate against both sexes. So I'm pretty sure we're fine, aren't we, Julie?
Or do you not find? No, because certain groups, including women, but also other groups that are less likely to be 6 foot tall, that rule will impact on them disproportionately and for no good reason. You do not need to be 6 foot tall to be a competent, successful police officer. So that's direct and indirect discrimination. Indirect discrimination is very hard to detect sometimes because often, particularly in traditional roles, traditional businesses, certain ways things are done have been done in that way for many, many years, and people don't think about whether something might be indirectly discriminatory. There are defences to discrimination. Merely because you don't achieve perfect equity in all respects does not mean that you are engaging in discrimination. The inherent requirements defence, what does that mean, Alana?
So a person cannot meet the inherent requirements of the job with reasonable adjustments, example, your disability or carer's responsibilities. It's something that's essential. It's got to be essential to the position. It's not just something incidental, peripheral, accidental, something that might be nice. It has to be an essential part of the role.
And the classic example is if you have an employee who has a long-term injury, they are physically unable to do the job anymore. The reason why you are perhaps terminating their employment is because they can no longer do the job anymore. That would be discriminatory, but for the fact that they can't fulfill the inherent requirements of the role anymore. They can't do the job anymore, and therefore it's a defence to discrimination law. There's another defence, unjustifiable hardship, where employees aren't required to make changes to the workplace or the method of work if it would result in unjustifiable or major difficulties, major costs. We probably see that less than the inherent requirements defence. But the blue box is important to remember. Employers must make reasonable adjustments unless this would cause unjustifiable hardship. In the ill and injured workers example, if you can make a reasonable adjustment to allow the person to do the role, their substantive role, then you should do that unless it's going to cause unjustifiable hardship. Here's a question that we received, which is an interesting one, and Bonanza is made up. This is actually not a question, it's kind of a problem scenario. Bonanza runs a stockyard in Queensland. The jobs they have involve the lifting of heavy bags and equipment hundreds of times each day. And what have they done historically, Alana?
They have hired men to do this work.
Yeah, and it's a very typical scenario that certain jobs in our society have had one gender do them historically and primarily even until this day.
But is this discriminatory? And do Bonanza run the risk of having a discrimination claim because they only employ men in this space?
Yeah, not prima facie, not simply because there are only men doing this work is it necessarily discriminatory. Bonanza absolutely cannot have a blanket rule saying they will only employ men. And so when it says because they only employ men in this space, I'm assuming Bonanza is not making that a requirement to hire people. The requirement to hire people is simply, can they perform the inherent requirements of the job? And just as Bonanza wouldn't hire a man who is not able to do the heavy lifting of bags and hundreds of times per day, if a female or anyone else is able to do that work, then that's fine. It's an interesting scenario. I would invite any employer who has work of this type, when I say of this type, heavily one gender or the other, to think about the form of work, to think about whether there's anything you can do to that form of work to make it more accessible to just simply one particular group, if only because lifting of heavy bags and equipment hundreds of times each day doesn't sound particularly safe for anyone. Yeah. So if there's a way that you can fix it so you wouldn't need that heavy physical strength, maybe you could do that. Is there anything else you wanted to add to that question?
But no, you covered my last thought was just on the safety, just thinking of the heavy bags hundreds of times a day. It feels like there must be an easier way, but that's more in the safety lens, not necessarily just discrimination.
Yeah, and look, obviously the answer is you cannot discriminate on the basis of gender, but if the inherent requirements of a role mean that you end up with the workforce that you have, then that's you have a defence. what can you do? We've got about 10 minutes to go, so we're going to go to a few more slides and then a few more questions. So this is a good slide which many people will have seen before. This is the reporting and complaints procedure. Alana, you have mentioned at least 3 times that the point of all of this is having a process, having a procedure. Do you want to take us through some of the elements of this slide or say something more about that point?
These are fantastic elements that should feature within any system or process that you adopt. So, for example, confidentiality. Now, confidentiality on its face is obvious because if you do not keep these processes and management of these sensitive disclosures and complaints with the necessary confidentiality, your workforce will lose trust in you, in your capabilities to manage these complaints, and then that will impact on how many people will actually engage with you. And if people are experiencing harassment, discrimination, or bullying in the workplace and they're dissatisfied with the internal processes, you're increasing the chance that they'll go to external processes, which of course people are welcome to do, but if they don't have any suitable options internally, they might go to the Fair Work Commission, get a stop bullying order, stop sexual harassment order. They might go to the tribunals to seek remedy with regards to harassment, discrimination complaints. Those other avenues, become more attractive when they feel like there's no options.
Well, they might go to a television show.
Go to a current affair.
It's incredibly important to be able to manage things in-house, not only from the cynical view of, well, we want to make sure that our dirty laundry stays in-house. There are very good reasons why you do not want things to play out publicly. There are very good reasons, including cost reasons, why you don't want to be in the Fair Work Commission or any other court fighting about these things. But the other reason is you are just more likely to get meaningful solutions to problems, quick, easy, acceptable solutions to problems before people lawyer up, before they hire publicists, but before they've started to write the complaint letter. And the only way that you can reasonably expect employees to engage with you internally is to have a process that's clear, accessible, and as you say, something that they acknowledge has some authenticity, some robustness, some fairness about it, and get them to trust in the system. You're just much closer getting them to trust in you as an employer. Right of reply is an interesting one in the bullying, harassment and discrimination space. It's a touchstone. It's very, very important for procedural fairness to have a right of reply to anyone who's being accused of engaging in any inappropriate behaviour. There is an art to workplace investigations, and there is an art to people management in terms of engaging with respondents at a particular time. We have some questions on the line now, but also prior to the webinar about when do you contact the respondent in any form of investigation. My only observation about this, apart from saying it depends on the investigation, is to say that how you engage with the respondent and their trust in the process is really important to getting outcomes in this space. If respondents in this area can be open to the fact that they're going to get a fair trial, they're going to get a fair hearing, that their view will be able to be taken, they're much less likely to close down and to say, well, no, I definitely didn't do any wrong, or they're making it up, or there's no way that they could have interpreted what I said or did in that way. And if you can have that process, you're much more likely to get a good result, and you don't need to end in the binary process of either the accuser leaves their employment, or the person who's accused leaves their employment. If you did anything out of this webinar today, please make sure you've got a process. And I think we might even be talking about some upcoming training in this space as we get through the last few slides with 5 minutes to go. What would you do? What can you do, Alana?
So we always must start with the policies. We are definitely pro-policy. We just don't want you to only have a policy in this space. So it's always good to review your policies. Your policies should have a review date. In sexual harassment, that's obviously been subject to change in the past couple of years. So if you have a combined policy at this time for discrimination, harassment and bullying, this might be a good time to create that standalone policy that Julian advocated for before. Review your WHS procedures. It does overlap in this space. You need to have systems to manage risks to health and safety. And that's why we talked a lot about psychosocial hazards and psychological health. Now, it says on there, does your risk register cover psychosocial hazards? Now, some might just incorporate it into their existing registers for different jobs, roles, tasks, etc. Some businesses might prefer to have a separate psychosocial risk register altogether. Again, neither is either incorrect. You're allowed and you have that flexibility to choose what works best for your business. Then, of course, review your complaint disclosure and handling procedures. Do you need a separate one or a more refined one for managing sexual harassment complaints or disclosures in that space? And as we can see, there are managers and leaders confident in this space.
I'm getting a lot of questions here, Alana, about seemingly from managers talking about some level of anxiety about, well, what do? I don't really know whether I want a grievance procedure. If someone says something informally to me, do I need to go down the formal process, or can I just sit on it, or can I just forget it? Having some confidence in that space for managers and leaders is obviously key. And the last one, talking about confidence for managers and leadership, training in managers and leadership around these types of issues, around the process for grievances, but also the general law, what's acceptable, what's not. Do they understand their duties in this space? Do they understand the positive duty? Do they have some education, some familiarity with the various state of the law in this space? As you said at the start, some people are surprised at, some people just genuinely don't know that people are taking offence to what they say or do. Some people genuinely don't understand that a particular viewpoint, a particular joke, a particular comment, a particular behaviour could be offensive to some people. And it's not just on sexual harassment ground, cultural grounds, age ground, as we talked about with the texting. Having some training will build some confidence in your managers and leaders, and you'll get better results, I would say.
And we, of course, start and emphasise the importance of helping managers and leadership, because they're the ones that will need to be enforcing your policies, carrying out your procedures, and be the example for the workers and all members of the team. So that's why we're putting so much emphasis on the top there.
Outstanding point. Quick sale, Sexual Harassment Positive Duty Toolkit. If you do not know what we are talking about in the positive duty space, if you are worried and at all concerned about your compliance with the positive duty, please email that. We can walk you through the particular product that we've created to assist employers comply with their positive duty. ABLA exists, ownership organisation exists to help employers. We want to help employers comply with their responsibility, and that is a great product and a great first step, and considerably more steps after that in complying with the positive duty if you need it. There's another toolkit, Psychosocial Hazards. Do you want to say something about this?
Yes, so this is another very focused toolkit that's just really aimed to help you get started. If you're just struggling with how to identify psychosocial hazards, not sure how you can even create records, maybe you don't have any records in this space, this tool's designed to just get you started, give you templates to build upon and get going. And we've got that plan to lower risk discussion tool there that gives you the prompts to comply with those new factors that we were speaking about before.
Brilliant. We also, obviously, please get in touch if you are concerned about your policies, procedures, your contracts, if you need an investigator. There are some training. There's some training courses queued up. Please go to the website if you're interested in booking at our training. I think there's there's the little positive duty bump, and then I think, that's the website, which gets a wiggle. I do the Advanced Workplace Investigations training course. It's very interesting. I love those training courses because it lets me meet you and discuss this very interesting aspect of human behaviour and the law. You can subscribe to our newsletters and email us. Let's jump to a couple of questions, rapid fire, as we go out in the last couple of minutes. Let's go firstly to friendly face. Julian, if you have a team of mostly men, you try and rebalance it with more diversity when a vacancy comes up, ? I would say it's an interesting and much more common concern and interest that people have. As we were discussing earlier today, that type of move brings with it its own risks. If you have a team of mostly men and you try and rebalance it with one or two other employees who are female, you have to be conscious of the fact that you are changing the dynamic, and that change of the dynamic may give rise to risks to either side of the coin.
But there are also, this is where we might need to check if you should be applying for an exemption in this space. So under discrimination law, businesses can apply for exemptions, particularly when you're effectively engaging in a type of discrimination to remedy some historical form of another type of discrimination. But there's action you can do in this space. But as Julian said, you need to just be a bit careful.
Be careful, and think those kind of things through. There's another friendly face which says, what do you do about an employee who only ever wants to report things informally and never wants to go formal complaint process?
Well, one, I would be happy that you are getting any form of report or disclosure.
Always look on the bright side.
So that's one quite good. It is in itself, though, as there's sometimes debates about what is a formal versus informal complaint. The first thing I would say is when you're getting any form of disclosure, make sure you don't ignore it. Make sure you take it and do something about it. Now, there are circumstances where maybe the seriousness of it means you will have to undergo a formal investigation against the wishes of that employee. Then when someone makes a disclosure or a complaint, of course, they should express how they would like it to be handled, and you should listen to them. But that does not mean they will necessarily dictate to the business the process that has to be followed.
Risk is risk, and it's not going to be good enough. My golden rule, I love saying my golden rule. What will this look like if we do nothing? And merely because I said I want this off the record, it's going to look awful if something happens. And get people to trust in the system, and they're more likely to trust in the process. Can commenting on another person's accent each time they speak be considered harassment? Yes. Look, that doesn't sound like a great situation. Two more. Some comments from people saying they still use thumbs up. #caution. Absolutely.
Great comments.
Exactly. And why don't we just close this session out by answering one more question. Alana, can I tell you to please enjoy your birthday today? That's such a sweet question. Happy birthday, Alana.
Thank you.
It's been a pleasure to be with you all. We'll see you next time. And if you need anything from us, please contact us.